this morning in the motions for disqualification filed by the prosecution. The defense attorneys involved in these cases have been scheduled for different times. We'd asked if they could log on if able to, so we can make a cumulative record. It looks like all defense counsel involved are here except for Mr. Ruiz.
We do have one input per defendant too.
Okay. And that one's at 11 o'clock. All right, so Mr. Steinhoff, this is your motion. Do you want to tell the court?
Thank you, Judge. I'd ask that the responses be called differently or separately. I don't want to have just 6 attorneys all arguing at the same time on different files. So when we call the cases, I'd ask that they be called individually.
The court is making a cumulative record. I'll call each attorney individually that wishes to make a comment.
Understood, thank you. Judge, I read the transcript from the similar motions filed out of Mackinac. I just want to say at the outset of this, I'm not looking for a back and forth with the court on this. The facts are all very present, they're plain, they're unambiguous, and I think it's what we're going to do with those facts that we're here to address. So, and I understand that the decision in Mackinac is still under advisement. So at the outset, I think we should all reflect briefly on the role of the prosecutor in these types of proceedings. The Michigan Rules of Professional Conduct are very clear here. A prosecutor has the responsibility of a minister of justice and not simply that of an ordinary advocate. This responsibility carries with it specific obligations to see that the defendant is accorded procedural justice and that guilt is decided on the basis of sufficient evidence. So what that means is that no matter what is said, no matter what you say, Your Honor, we as prosecutors have to act in a way that protects us, the defendant, and the system. That's our obligation. So with that said, every fact I'm alleging is in my written motion, focusing first on the individual instances that reference the Alger County Prosecutor's Office and operations. Our allegation is that the utilization of the scheduling power of the court with the intent of forcing settlement short of trial in that case.
What case are you specifically referring to?
I'm referring to the text messages that were sent in September of 2022. That would have been People versus Pitawanaquat would have been one of the affected cases, and also People versus Sadowski. The next issue that we brought up in our motion is the impugning the charging discretion of the people, as well as singling out Alger attorneys for the direction of ire, and finally pointing to law enforcement witnesses as waste of time. So that's all in the motion. I'm not here to beat it up. I'm not here to again, not looking for a response necessarily. And I'd like to hone in on something else that I just tangentially touched on in the motion, and that's the totality of the circumstances. You see, when taking into account the actions of the court in reference to Mackinac and even Schoolcraft County, it raises a palpable question of, am I next? And
What actions are you referring to?
the exhibit that was associated
No,
with
but what actions? I understand there were words said.
the word said are the actions of reference.
So what actions? What actions can you point to? Actions speak louder than words.
Understood.
Actions speak, what actions can you point to that show that any case was not decided based on facts of the case and the law that applied to that case?
Right, and focusing on the scheduling power of the court, utilizing that in a way that's designed to bring about a settlement, rather than.
Let me ask you this: what percentage of cases settled before trial in a criminal case court?
In Alger County? I don't know the number off the top.
At least 95%?
Probably.
I mean, the statewide average is 97%,
Okay.
so it's at least 95%. What evidence do you have to show that the court scheduled that case any differently than it scheduled any other cases?
Well, I mean, that was the only case scheduled for trial 2 weeks before the Sadowski trial.
So?
Okay. My allegation is made, Your Honor, I'm not looking for the fight here.
Well, no, I'm asking you to present evidence. So here's my, you have access to the Register of Actions in the Pitawanaquat case, right?
Sure.
Did you review that?
No.
Okay. So you made an allegation with actually not reviewing the case. Is that accurate?
I reviewed my own file, Judge.
Okay. Here's what the Register of Action says. June 22nd, 2022. Second pretrial. After the defendant's already been sitting for 8 months in jail without a trial.
Okay.
You agree that the defendant in particular has a right to a speedy trial.
Sure.
Okay, so 8 months of speedy trial?
I don't know in the instances of that case,
Okay.
Judge. I was straight on the heels of COVID. We did 12 trials that year.
Oh, okay. So this, in June
Mr.
22nd,
Sadowski sat for 4 years. I mean,
right, and the defense kept requesting adjournments, as did you. Apparently,
don't recall requesting an adjournment in the Sadowski matter, Your Honor. At least by myself.
I apologize then. So, here we go. Second pretrial, June 22nd, 2022. Defense requests a 2-day trial. Defendant has been sitting for 8 months. They request a bond reduction. Prosecutor objects. Court agrees with prosecutor, does not grant the bond reduction due to fear that the defendant would not appear for trial. Prosecutor responds, or states, August is the earliest that we would be ready for trial. The prosecutor has stated to the court on that day that he would be ready for trial in August. Was that a lie?
I don't lie in here, Judge.
Okay, so now you're lying today saying that you could not be ready for a trial in October.
I'm not picking up what the court's laying down here.
Well, I assume you would not. So
Okay.
you're this is my courtroom.
Understood, Judge, but I also have.
You'll have a chance to make your comments. August is the earliest that we'll be ready for trial. Okay? You were not going to be ready for trial in August, apparently. You misled the court. Is that what you're saying?
No.
Okay. We'll have scheduling clerk look for dates, possibly. Possibly set his primary date for August or September. So we set the court, so you reach out to the scheduling clerk who scheduled the trial for October, probably after some discussion with you. Would you agree with that?
I don't know if there was discussion had. I do agree that August and September seems more reasonable.
Okay. So you would have been prepared in August, but not in September, or in September, but not in October.
I think you're conflating two issues, Your Honor, with respect. The issue was the nearness of the setting of the trial to the murder trial.
So you had, as you said, 4 years to prepare for the murder trial, and you were not ready to try that case
Well,
because of a 1 or 2 day trial.
I think it was a 5-day trial, wasn't it, scheduled for? Was it a 1 o'clock trial?
No, it was scheduled for 2 days.
Okay. Yeah, well, as the court's aware, when prepping for a trial, the majority of the work happens up to and then leading to the day of the trial.
So you were unable to manage your time appropriately.
I think that's a matter of opinion, Judge. That's your opinion. I disagree.
Okay.
May I continue, Judge?
No. I don't know what the trial schedule was. The trial scheduling of this court has varied a lot since these times. But we have a defendant who had been sitting in jail without a trial. You agree that that's cannot happen.
Sitting in jail without a trial, we have a lot of defendants sitting pre-trial. And we argue for that often.
Post after 8 months?
Yes, even after 8 months.
Right. So we tried to schedule them, and I'm pretty hard and fast about scheduling within 6 months unless both parties, because it's the defendant's right to a speedy trial when they're sitting in jail, unless the defendant waives that right. All right, you may continue.
The concern that we have going forward is the capability and predisposition of the court to direct hire at a litigant in a way that disadvantages the litigant and shows bias, much like what has been done with George Hyde or Dan Mead or Stuart Spencer. So,
Hang on. What does that have to do with you?
well,
Because, for one, there's no showing that this court has taken anything out on any cases that was not decided on facts and law. You have not shown any of that.
I disagree with that, Your Honor. but, and it specifically is the scheduling matters.
The scheduling matters is within the clear purview of the court.
Understood, but it happened, and we know why it happened.
You do not know why it happened.
Oh, well,
You have no idea what happened. You really think.
it'll settle. Oh, well.
And was I right?
Oh, yes, you were right.
Because you didn't want to take the time to prosecute the case, is that why?
Your Honor, please don't put words in my mouth, because you know that's not true.
Isn't it?
Thank you.
97% of cases settle before trial. So to say, if I say it will settle, I have a 97% chance of being right. No matter when it's scheduled.
Man.
You may.
So as far as the law is concerned, this totality argument in the greater context, the real question is, based on an objective viewer, has the judge failed to appear to an appearance of impropriety standards set forth under the ethics canons? And I don't think there's a reasonable person that can say otherwise here. And I take no stock in the conversations being public or private. I don't envy the position of the court. But
So you've never had a private conversation to talk about other attorneys or cases or,
I'm not a judge, so I don't think that question is necessarily relevant.
so you've never sat in my chambers to complain about other attorneys?
I don't recall, I've never called other attorneys morons or douchebags or called elected women bitches, but I'm sure we all complain, Judge.
Okay. I agree, we all do complain in private.
But we're not all judges.
Okay.
I think that situation alone demands disqualification, but that's just one ground, that's just the appearance of impropriety. The other avenue for disqualification asks whether there exists a serious risk of actual bias impacting the due process rights of the party. And again, both specifically and viewing the messages as a whole, I think the facts supporting our allegation are very plain. And finally, disqualification is warranted if a judge is biased or prejudiced for or against a party. So in Mackinac, that's not really a question, and I'll concede here, Your Honor, that the bias is less apparent, but it doesn't actually exist. But it does actually exist, in our view, on what was said about the people's charging discretion and the court's intent when scheduling cases, and singling out of Alger County attorneys, which there's only 4 or 5. And finally, addressing the law enforcement directly as it relates to the waste of time. So again, Your Honor, I'm not looking for a back and forth on this. It's not an explanation I'm looking for, it's an investigation. And I want that to guarantee that our rights and the rights of everyone in this room are protected, especially with the That's all.
Thank you. Mr. Harmon, do you wish to make?